My name is Levi Trumbull. I'm acting as a process server tonight. I'm from the Circuit Court for Washington County.
No, wait.
I am hurt. What's that?
This is not appropriate.
What's not appropriate? I'm here to serve a subpoena. Hey everyone, Levi here, and hang tight. We have an amazing story for you guys today that marks another big win for government accountability, and you are going to want to hear all about it. But first, before we dive into today's video, I wanted to briefly hit the pause button and thank everyone for getting this channel to over 100,000 subscribers. At the end of the day, it is your support and your viewing and your sharing and your subscribing to these videos that keeps this thing going. It keeps me focused, and most importantly, it keeps me pressing. So thank you for that. And with that being said, if you are new to this channel, now is a great time to subscribe. We have a lot of great things that are coming in the future, and we want you to be in the loop for all of that. So with that said, let's talk about why we are here today. I want to talk about a recent finding from the Maryland Open Meetings Compliance Board regarding the Keedysville, Maryland Town Council. The board recently concluded that the Keedysville Town Council violated the Open Meetings Act by holding a meeting via email back in 2020. The complainant, Justin Holder, who is also a friend of this channel and also a property owner in the Keedysville area, alleged that the council improperly met through email to discuss the installation of a street light. The council, which has 5 members, argued that the act didn't apply to the email exchange because, in their view, the emails didn't, quote, constitute the assemblage of a quorum. They also claimed that the emails were just an administrative function which wouldn't trigger the Act's requirements. However, the Open Meetings Compliance Board disagreed with the town council on both points. They concluded that the email exchange was a meeting and that the discussion was not an administrative function. Because of this, the board found that the Act applied, and the council's failure to provide public notice and an opportunity to attend the email meeting was in fact a violation. So let's break down the timeline of emails that led to this decision. The first set of emails happened in March 2020. On March 9th, a council member emailed an employee from an electric company about the placing of a streetlight and copied the other 4 council members on the email exchange. Over the next week, there were a few reply-all emails between the electric company employee and a town administrator, with all council members copied onto that email regarding scheduling a time to stake the streetlight's location. The board found that these particular emails in March did not constitute a meeting because only one council member was actively sending these messages. However, things did change in April. On April 8th, the electric company employee emailed the town administrator with an update about the streetlight. The employee presented 3 different options for how to proceed with the installation, and the town administrator forwarded this email to all 5 council members with this simple message, quote, "Thoughts." Over the next 3 hours, 4 of the 5 council members, which is a quorum, responded using reply-all emails. One member even replied directly to another council member's comment. The board determined that this exchange was, quote, so tightly grouped as to amount to a meeting of quorum. They also found that the topic was clearly, quote, public business, because the town council has the authority to regulate town lighting. Now, about the council's second argument, that this was just an administrative function. The board explained to be an administrative function, the discussion cannot be legislative, judicial, or quasi-judicial. In this case, the board concluded that the email exchange didn't fall into any of those categories. But that's only the first part of the test. The second part requires the discussion to be about administering the existing law or policy. The town council pointed to sections of the town charter and the Maryland Code that gave them power to create ordinances for things like public lighting and resident safety. However, the council failed to identify any specific ordinance or regulation that they were actually applying in that email exchange. The board has a long-standing position that a public body isn't acting for an administrative capacity when it acts under a general enabling provision without a specific existing law or policy to administer. So, because there was no specific law being applied, the board concluded that the email exchange was not an administrative function. In their final conclusion, the board stated that the Keedysville Town Council convened a meeting when a quorum of the body exchanged 5 emails on the same public business matter within a 3-hour period. Since this meeting was not an administrative function, it should have been open to the public, and the council's failure to do so was a violation of the law. So there you have it. This is a clear reminder that in the age of digital communication, the rules of transparency still apply. It's not about where the meeting happens, but whether a quorum of a public body is discussing public business. The Open Meetings Act ensures that the public has a right to be part of those conversations, no matter which format they present themselves in. As such, Keedysville will now have to acknowledge their violations to the public at their very next public meeting. All right, guys, what's happening? Levi Trumbull reporting here, and today we are in process server mode here in Keedysville, Maryland, outside of their government building. So let's just say I received a very unwelcoming reception just a moment ago when I went inside of this building to serve Judy Kearns with a copy of a subpoena as it relates to a lawsuit, a Maryland Public Information civil case filed by Justin Holder. And as you're going to see in this footage before you in just one moment, they thought I had no right to do that. So with that, guys, we'll catch you soon. I guess this would be the right time. I mean, I didn't sign up. I just signed up to get in here.
Oh, you didn't sign up to speak?
Is this a speaker's comment? No, you just told me to sign in.
Right. Do you want to speak?
Well, I guess this is probably an appropriate time. So I just have something. Actually, I just have something. I don't need to speak. I just have something for you, Miss Kearns. My name is Levi Trumbull. I'm acting as a process server tonight. I'm from the Circuit Court for Washington County.
No, wait.
I am hurt. What's that?
This is not appropriate.
What's not appropriate? I'm here to serve a subpoena.
Any public meeting, you can do it after the meeting, but not during.
Not during the public meeting?
Not during the public.
So you want me to stick around and then give it to her?
Well, if that's what you have to do. If she's
But I'm right here, right now. Why can't I serve her right now?
waive it and accept it, that's fine, but generally.
Okay.
Can't be served in court, or they can be served during a public meeting or a legislative session. So.
How do you know that?
It's his job.
It's his job? Okay, I'll hang around. That's fine. That's fine. No problem. I wasn't here. Walked in a little bit late.
I walked in.
What's that?
You were standing there when I walked in.
Okay. You want to take it right now? You want to take it right now? No? Yes or no? Do you want to take it?
Yes.
Well, okay, thank you. Okay, so I'm here to serve a subpoena, as you know. We'll get this out of the way. All right, you have to testify in person for Justin Holder versus Town of Keedysville et al., September 24th, 9 a.m. Here you are, ma'am. Do you have any questions? Have a good night. Thank you. Thank you, officer. Appreciate it. Yeah. And with that, thanks for watching. Levi Trumbull here, and I will see you on the next one.